The clock is ticking, and if you're a green card holder in the United States, what I'm about to share with you could completely change your immigration status in 2026. Congress just passed a sweeping new immigration law that directly impacts millions of permanent residents, and the changes are so significant that immigration attorneys across the country are urging their clients to take immediate action. Whether you've had your green card for 2 years or 20 years, this update affects you, and ignoring it could put your entire future in America at risk. Stay with me until the end of this video because I'll break down exactly what you need to do right now to protect your status and avoid potentially devastating consequences. Welcome back to the channel, and if you're new here, make sure to hit that subscribe button and turn on notifications because we cover critical immigration updates that could affect your life in the United States. Today, we're diving deep into the newest immigration legislation that just cleared Congress, and trust me, this is not your typical bureaucratic adjustment. This is a fundamental shift in how green card status will be maintained and verified starting in 2026. Let me start by giving you the context of why this law came into existence. Over the past several years, there's been growing concern in Washington about what they call green card abandonment and fraud. Essentially, Congress has been worried about permanent residents who maintain their status on paper but spend very little time actually living in the United States. While previous administrations dealt with this on a case-by-case basis through immigration courts, the new legislation creates systematic requirements that every green card holder must now meet. The centerpiece of this new law is what's being called the Enhanced Permanent Residence Verification System. Starting in April 2026, all green card holders will be required to file an annual status confirmation with United States Citizenship and Immigration Services, commonly known as USCIS. Now I know what you're thinking, another form to fill out, another fee to pay. But here's where it gets more serious than just paperwork. This annual confirmation isn't optional. It's mandatory, and failure to file can result in automatic initiation of removal proceedings. Let me break down exactly what this annual confirmation entails. Every green card holder will need to submit documentation proving they spent at least 183 days physically present in the United States during the previous 12-month period. That's just over 6 months. You'll need to provide evidence such as employment records, lease agreements, utility bills, bank statements showing domestic transactions, and even things like school enrollment records for your children. The law specifically states that USCIS can request additional documentation if they have any questions about your physical presence. Now here's something that's catching a lot of people off guard. The law also introduces new employment verification requirements specifically for green card holders. If you're working in the United States, your employer will now be required to verify your permanent resident status through an expanded E-Verify system every 6 months. This means that HR departments across the country are scrambling to update their systems and processes. If you're self-employed, you'll need to provide quarterly tax payment records and business documentation showing active operations within the United States. But wait, there's more, and this is where it gets particularly tricky for certain groups of green card holders. The new law creates special scrutiny categories for permanent residents who obtain their status through investment programs, also known as EB-5 visas, or through employment sponsorship in specific industries. If you fall into these categories, you'll face additional quarterly reporting requirements and may be subject to random in-person interviews at your local USCIS office. One of the most controversial aspects of this legislation is the travel restriction modification. Previously, green card holders understood that being outside the United States for more than 6 months could raise questions about abandonment of residence, and being gone for more than a year without a re-entry permit could result in loss of status. The new law tightens this considerably. Now, any absence from the United States exceeding 90 days within a 12-month period triggers an automatic review of your permanent resident status. You'll need to file a specific form explaining the reason for your extended absence and provide documentation supporting that your ties to the United States remain stronger than your ties to any foreign country. This has huge implications for green card holders who travel frequently for work, who care for elderly parents abroad, or who maintain business interests in their home countries. Immigration attorneys are advising clients to start documenting everything, and I mean everything. Keep copies of your boarding passes, hotel receipts, work assignments, medical records if you're traveling for health reasons. Anything that proves both your travel necessity and your intention to maintain the United States as your permanent home. The law also introduces something called the Green Card Renewal Fast Track Program, which sounds positive, but here's the catch. To qualify for this fast track, which reduces renewal processing times from the current 18 months down to just 3 months, you need to have perfect compliance with all the new annual reporting requirements, zero travel violations, and continuous employment or education documentation. If you don't meet these strict criteria, you're stuck in the regular processing channel, which under the new law could actually take up to 24 months. Now let's talk about the financial implications, because this isn't just about paperwork and compliance. The annual status confirmation filing comes with a fee of $275 per person. If you have a family of 4, all green card holders, that's $1,100 every single year just to maintain your status. The law does include a hardship waiver for those who can demonstrate financial inability to pay, but qualifying for that waiver requires extensive documentation of your financial situation. Here's something that's particularly important for those of you who are planning to apply for citizenship. The new law actually creates an incentive structure to encourage naturalization. If you've been a permanent resident for at least 3 years, if married to a U.S. citizen or 5 years otherwise, and you file for naturalization within the first year of this law's implementation, the naturalization fee is reduced by 40%. Additionally, the processing time for these early applicants is guaranteed to be no more than 8 months. This is clearly designed to push eligible green card holders towards citizenship and reduce the permanent resident population. For those who are not yet eligible for citizenship or who choose not to naturalize, you need to understand the penalty structure. Missing your first annual confirmation deadline results in a $500 fine and a formal warning. Missing a second deadline within 5 years results in a $1,500 fine and mandatory appearance before an immigration officer. Missing a third deadline triggers automatic removal proceedings. There are no exceptions unless you can prove extreme circumstances like hospitalization, natural disaster, or other documented emergencies. The law also grants USCIS expanded authority to conduct compliance audits. This means they can randomly select green card holders for detailed reviews of their status maintenance, even if you filed all required documents on time. During these audits, which the law says should affect approximately 5% of permanent residents annually, you may be required to appear for an in-person interview, provide additional documentation going back up to 5 years, and in some cases undergo biometric reappointment. One provision that's getting a lot of attention from immigration advocates is the good moral character continuous assessment requirement. Previously, good moral character was primarily evaluated when applying for naturalization. Under the new law, USCIS can review the criminal and civil records of any green card holder at any time. Certain offenses, even misdemeanors, can now trigger status review proceedings. This includes things like DUI convictions, domestic violence charges, fraud, and even some traffic violations if they demonstrate a pattern of disregard for U.S. laws. So what should you do right now to prepare for these changes? First and foremost, start organizing your documentation immediately. Create a comprehensive file that includes your travel records for the past 3 years, employment documentation, tax returns, proof of residence, and any other evidence of your life in the United States. Second, review your travel plans for 2026 and beyond. If you have extended international travel planned, consider consulting with an immigration attorney about whether you should adjust those plans or file for advanced documentation. Third, make sure your address is updated with USCIS through the AR-11 form, because all notifications about these new requirements will be sent to your address on file. If you're eligible for citizenship, this might be the perfect time to seriously consider naturalizing. The financial incentives and processing time guarantees for early applicants make this an attractive window. Even if you've been hesitant about giving up your home country passport, remember that many countries now allow dual citizenship, and the benefits of U.S. citizenship, including voting rights, passport strength, and immunity from these new green card regulations, might outweigh your concerns. For those who spend significant time outside the United States for legitimate reasons, start building your case now. Document everything about why you need to travel, how you maintain your U.S. residence, and what ties you to America. Get letters from employers, medical providers, or family members that support your situation. The stronger your documentation, the better position you'll be in when these annual confirmations begin. One more critical point: scams and fraud are already emerging around this new law. Be extremely careful about any communication claiming to be from USCIS that asks for immediate payment or personal information via email or phone call. USCIS communicates primarily through official mail to your address on record. Always verify any requests by calling USCIS directly using the phone number on their official website or by consulting with a licensed immigration attorney. This new legislation represents the most significant change to permanent residence requirements in over 30 years. While it creates additional burdens and costs for green card holders, understanding these requirements and acting proactively will help ensure you maintain your status without interruption. The key is not to wait until the April 2026 implementation date. Start preparing now. Get your documentation in order, consult with professionals if needed, and make informed decisions about your immigration future. If you found this information valuable, please give this video a thumbs up and share it with any green card holders in your life who need to hear this. Drop a comment below telling me what concerns you most about these changes or what questions you still have. I read every comment and often create follow-up videos based on your questions. Don't forget to subscribe and hit that notification bell so you never miss critical immigration updates that could affect your status in the United States. Remember, knowledge is power, especially when it comes to protecting your right to live and work in America. Stay informed, stay compliant, and I'll see you in the next video where we'll dive into specific strategies for documenting your ties to the United States under these new requirements. Until then, take action now and protect your future.